thanks, Tola, for the kind words about me. But you forgot to mention one thing, that I'm on the board of tralac. I'm a board member of tralac. I value that very much. And I've been with Erasmus, Trudy, Teko, Paul Kalenga. All these are my colleagues. I met through tralac. Very good experts. And we've shared great intellectual moments together. I've got only less than 1 hour, so I'll just sound certain issues involving the regional competition policy in COMESA. First, without wasting time, I'll talk general remarks on what is COMESA. Then talk about the challenges presented by the proliferation of national competition laws among the COMESA member states. And then why do we need a regional competition policy under COMESA? What are the treaty provisions under the COMESA Treaty itself? And then the obligation of member states under the COMESA Treaty. And then we'll talk about how we commenced the enforcement of competition policy under COMESA and the challenges, and then the concluding remarks. I've got 20 slides. I assure you I'll spend 1 second per slide. So within 20 seconds, I should be through. What is COMESA? COMESA has got 19 member states, as you can see. I've got the statistics for 2008. Why 2008? Because these are the true statistics. After 2008, there are conflicting figures, so I couldn't use them. But in 2008, we had about 430 million people in the 19 member states, and the annual import bill of around 152 billion US dollars, and the export bill of 157 billion. It forms a major marketplace for both internal and external trading. So you can this just gives you the idea of what area you're talking about in terms of trade, how much trade is transacted in this area. It is vast, and this is quite impressive. It is about 12 million square kilometers. So this is the market you are talking about, and I think it may be the biggest market in Africa when you talk about the COMESA market. If you look at the map, you can see its coverage, that very soon, more members have applied. We've got the New Sudan. It has made an application, and I'm being told that certain members who left COMESA are planning to come back so that we surround South Africa. Trudy. Yeah, so if you look at, there's a multiplicity of membership. We've got 8 COMESA member countries who are part of SADC. We've got 4 who are part of the East African community. And as it has been mentioned by Trudy and the professor, there are some negotiation now about the tripartite FTA. So that is, we don't know whether it will happen in our lifetime. When the professor this morning was talking, I wanted to ask him, is it possible today to negotiate the COMESA Treaty or the SADC Treaty? I don't think so. It will be a story of EPAs. I started attending EPAs workshops when I was quite young. I was still keeping my hair. But up to now, people are still writing about EPAs. So I don't think today, the way the world is, we can negotiate the COMESA Treaty. But it goes again what the professor was saying, Professor Mkandawire was saying, that the eyes, the individuals, all those things come to play, and it becomes difficult to get any consensus. But talking about the competition, if you look at the countries involved, find that most of them now, it is not an issue whether we need competition now in the region or not, or at national level. All these countries now we've got national competition laws, apart from Congo, Eritrea, Libya, and Uganda. Uganda, Congo, Eritrea, they should, by the end of this year, they'll have their I think maybe by next year we may have Libya. So it shows really that we've moved at a higher level. When we started talking about competition in the region, we had only 3 countries, which was Zambia, Zimbabwe, South Africa, and 4 plus Kenya. But now we are talking about almost everybody having a national competition law. Now, having so many national competition laws, what were the challenges? There were a lot of challenges. When we started implementing at a national level, we found that there was a lot of duplication. One conduct which was being investigated, say in Zimbabwe, was being investigated in Zambia, it was being investigated in Malawi. And each one of us will come up with different decisions, and this was not healthy for the business in the region. There was so much uncertainty with most of the transactions. You'll find that most of the decisions we were making, like in Zambia, do you recall, we made a decision that for Lafarge to take over the cement factory, which was Chilanga Cement Factory, first they had to satisfy the local market, the domestic market, before they could export. But during that time, Rwanda and Burundi were dependent on the Zambian cement to develop their industrialization in Rwanda. And at the same time, Zambia was opening up more mines. So there wasn't enough for Chilanga to export to Rwanda and Burundi. And with our conditions which we gave to Chilanga Cement, so our decision was affecting the development, the construction industry in Rwanda. So those were the issues which were, it was not only in cement, it was also in sugar, in most of the industries. Further, in our investigations itself, we found that most of the evidence which we required in order to make a sound competition assessment, it was located outside our jurisdiction. It was very difficult for us to coordinate well our decision in the region. Whereas most of the companies, you'll find that the headquarters in South Africa, but the same company will be operating in Zambia, Malawi, Zimbabwe. But there was no coordination among the competition authorities. We were not looking at the market as a regional market. There was self-interest, national interest. A good example is Lafarge, again, when it was taking over the companies. We found that in Malawi, the competition authority was not operating. And their intention was to close up the Malawi plant so that the cement from Zambia could also service the Malawi market. But fortunately, at that time, I knew Honorable Kazembo was Minister of Trade, so I was able to talk to her. And that's how she stopped the closure of the cement factory in Malawi. But again, there was no coordination amongst us. Remedies which were being perpetuated, also there are the negative effects in the other markets. For the lawyers themselves, there was a problem with the knowledge and compliance with the different legal systems. You find that you're in Zambia, you'll be told to supply certain information. In Malawi, to be different information. In Zimbabwe, different information. The cost of doing business were becoming higher, waiting times. You find the Zambian Competition Act didn't give time specific in which to make a decision. So you find lawyers were waiting for this uncertain time to wait for the decision by the Zambian Competition Authority, by the Zimbabwe Competition Authority, by the Malawi, Swaziland. So the whole thing was so unpredictable, which was bad for business and for investment in our region. Compliance with forms, fees payable. Most of the competition authorities depended on the fees for their operations. And about certain countries was almost 95% of their budget was obtained from fees. In a situation like that, you find instead of looking at competition issues, the competition authority would became a revenue collector so that it pays salaries. So the objective were being displaced by lack of funding from the member states to meet the operations of competition authorities. Review schedules and waiting periods. So we met in Livingstone, and I think, Trude, I think you came to that meeting in Livingstone. We started talking about the need for the COMESA competition regulations. We looked at the two statutes, the SADC protocol and the COMESA. We found that the COMESA treaty was the most ideal to come up, start thinking about having a regional competition regime. We were affected by the globalization of the region. We found that the impact of anti-competitive behavior often went beyond the national borders. In South Africa at that time, there was a lot of busting of cartels. You do recall there was the fertilizer, bread, construction cartels. If you look at the companies involved, those companies were also operating in Zambia, Zimbabwe, Swaziland, Botswana, Lesotho. So if they made money out of the cartel behavior, exploitative profits, then it means that even in these other countries, they were making the same unlawful profits. Later, we found the measures themselves, which involved, for example, Game Stores and Walmart, Lafarge in the cement sector, Ilovo Sugar, and the South African breweries. All these measures and other forms of acquisitions were also affecting all the region, the Southern and Eastern African region. But again, these issues were being looked at national level, and there was no coordination among ourselves. And, you know, at competitive practices, mostly it is behavior, it is like a disease. Cartel, it is like a disease. It's bad behavior. The only way to kill malaria is to treat everybody in the house. Leprosy, measles, whooping cough, what others? All these diseases. But we are treating one person and leaving him to go scot-free, so that behavior will come back again. So we're scratching just the surface in dealing with these issues. So in Livingstone, what there was the dilemma? We had a meeting, we invited also a tralac to deal with 3 questions only. We invited also the South Africa Competition Authority to come and assist us, the AU, ACTANT, everybody to Livingstone. And 3 questions were asked. Are the respective national competition laws of member states and their enforcement sufficient to deal with the market problems of the regional nature? That was the first question we dealt with in the 3-day seminar. Second, is it prudent for the countries in the region to continue relying on the domestic laws, yet at the same time work toward the development of a more seamless regional system that facilitates the working of regional markets? And the third question we dealt with, what new tools, tasks, and concepts will be needed to address the competition issues that are emerging on the horizon of the regional and global economy? Everybody was there. It was the most well-attended conference, and I've forgotten which year was that. That was in 1998 or 99. So we pondered on these 3 questions. What came out was that we should go back to Article 55, 1 of the COMESA Treaty. This article was the answer to most of the problems we had, that at regional level, there was a provision that member states agreed to prohibit an agreement between undertakings or concerted practice, which has its objective or effect the prevention, restriction, or distortion of competition within the common market. And the treaty itself, we found that it allows the council, by council we mean the ministers of trade, to make regulations to regulate competition within the member states. So with these 2 provisions, we were able to convince COMESA to start the process of coming up with the regulations. And those regulations are what are called now the COMESA competition regulations, which were ratified by Council on 17th December 2004. This is about 10 years ago, is it? If I'm right. This is 2014. So what are the effects of this regulation on our member states? Article 10.2 of the treaty itself, it says the regulation shall be binding on all the member states in its entirety. So they are binding on all the 19 member states. Entry into force. How does the regulation come into force? And again, Article 12.1 of the treaty says regulation shall be published in the official gazette of the common market and shall enter into force on the date of their publication, such as in 2004. So immediately they were published, in 2004 they were supposed to have entered into force. Unfortunately, they couldn't get into force because there was no money to start up the commission. Now, what is the effect of the regulation of member states? Again, we come to the polyol paints and adhesive manufacture, the case which is now very popular, being a lot of commentaries have been written on this case. But as regards what is necessary to us, there are 4 issues were mentioned in this case, and which are, is it William? William alluded to this. And there's a good article actually by Professor Erasmus. I think it is on the tralac. There are 2 good commentaries on the tralac website involving this case, which I would advise, recommend that you should look at how the review of this case by tralac. I think there's one by Erasmus and one by William. Very good analysis of the case. But 4 issues came out. 1, failure by COMESA member state to domesticate the regulations by giving them the force of law and the necessary legal effect within their territories constitutes a breach of the COMESA Treaty. So failure to domesticate is a breach of the treaty. Secondly, member states can be taken to the COMESA Court of Justice by other member states or the Secretary General for breaching the treaty by failing to fulfill their obligation under the treaty. These are very important powers which have been given to the Secretary General and to the member states, other member states. Thirdly, legal or natural persons have enforceable rights to take their member state governments to the COMESA Court of Justice in respect of conduct or measure that prejudices them and constitutes a breach of the treaty obligations. And fourthly, that member states cannot use their internal laws as an explanation or defense for not implementing the COMESA treaty obligations. This was very important for us, for the COMESA Competition Commission, and it was very also important for all the trade-related regulations. Because what was happening was that most of our business people and member states couldn't go enforce the treaty obligations at domestic level because most countries were saying we haven't domesticated the COMESA treaty. And there is a case actually in Swaziland, which I'm pushing to get the record of, where a company was told you can't seek relief under the COMESA treaty because this treaty is not recognized by our domestic laws. It hasn't been domesticated. So the treaty itself, there are also, again, obligation of member states. I'll read the last leg of these obligations, which says member states shall abstain from taking any measure which could jeopardize the attainment of the objective of these regulations. This is a familiar provision. You'll find it even in the ESC. And the Article 5.2b of the treaty says each member state shall take steps to secure the enactment of and the continuation of such registration to give effect to this treaty, and in particular, to confer upon the regulations of the Council the force of law and the necessary legal effect within its territory. So these are obligations under the COMESA Treaty itself, and which makes most of the regulations by Council of Ministers enforceable at their member state level. Now, these COMESA competition regulations, what do they bring on the market? Because most of the lawyers and the business people, as Professor Mkandawire said, what is there for us? You are talking about integration, what is there for us? So what is there for the businessman, for a citizen of COMESA, by bringing on the market these regulations? These are the major control regime of COMESA came into force. So we came into force on 14th January 2013. That's when we opened the doors. And then it seeks to offer a one-stop shop for the filings in the common market. I'm using the word it seeks rather than it offers. It seeks to offer. Why? Because we've got a problem. And that problem comes to the issue of domestication. And I also try to direct William to the communique, head of state's communique after the summit in Kinshasa. Where is William? To add it to his paper, the communique by the heads of state in Kinshasa and by the Council of Ministers, where they dealt with this issue of domestication. Directives have been given and urging member states that by December 2014, they should show that the domestication process is either complete or member states have taken steps towards domestication of the COMESA Treaty. This means that all transactions with an appreciable effect on trade between member states must be filed with the COMESA Competition Commission. For such a transaction, there's no need to file with individual member states. Now we've got one-stop shop for all transactions with cross-border effect. We'll come to that. With the coming of the COMESA competition regulation, there are now two separate legal regimes which govern the enforcement of competition policy in COMESA. The national competition law route, which is still there, but this deals with all transactions within the border of which respective COMESA member state. But where there's a cross-border effect, then the jurisdiction shifts to the COMESA Competition Commission. What is the scope of application? Put differently, the regulations apply to all economic activities, whether conducted by public or private persons within or having an effect in COMESA. But it's important to note that they apply to conduct which has an appreciable effect on trade between member states and which restricts competition in the common market. So it is important to know that there are three criteria which is used. The first criteria is appreciability. It should be appreciable, not every contact. Through the conniving with Itula to sell mangoes at Tupola, that has got no appreciable effect on the trade. It should be something which changes the structure of the market for it to be, to concern us. Secondly, it should affect the trade between member states. It shouldn't just be restricted, although we can call for a transaction which is national but has got an effect at the regional level. And it should restrict the competition. So that is very important to know the scope of application, where this regulation, in which situations they apply. There is a relation between the national competition authorities and the regional competition authority. we haven't displaced the powers of the national competition authorities. Even before we came into force, the national competition laws were limited to their national territory. They had no supranational powers to deal with outside their boundaries. So the national competition laws are still intact, and they are still carrying out their enforcement duties. We have just come to supplement where there was inadequacy, where they couldn't deal with anti-competitive practices or transactions which emanated or which went beyond their borders. That's where we've come in. But otherwise, the status quo of the powers of jurisdiction of national competition authorities, they are still there. But we've just come to enforce where there was that inadequacy of dealing with anti-competitive practices of cross-border nature. What is the dispute resolution mechanism which is embodied into the enforcement of competition laws? Apart from the two-tier system we have, parties to the transaction can appeal to the committee of initial determination. If they are not happy with the decision, it goes to full board of the COMESA Competition Commission, which comprises of 9 to 13 members. If they are not happy with the decision, it goes to the COMESA Court of Justice. Again, if they are not happy, it goes to the appeal court of COMESA Court of Justice. The major function of the COMESA Court of Justice is to ensure adherence to the law in the interpretation and application of the treaty. So far, we haven't been taken to the COMESA Court. But as you can see, the world is changing, so is our region. The Mauritius case is the beginning, but I can see more cases now going to the COMESA Court of Justice. Why? Because there's been a shift. Professor, I think now the businessman of today is different from the businessman of yesterday. Why there are no courts before the SADC tribunal, no cases before COMESA of business nature? It was because business was confined to most of the local people. Nationalization, Chama Pindus, Kaunda's UNIP, Harambe Wat. So there was this brotherly way of solving issues. But now with globalization, we've got different companies coming to trade in our area who don't believe into this brotherly way of solving issues. They will rather go to court. And this we can tell by so many notifications being made before the Registrar of Companies, Patent Office, the opening up of commercial courts. All those things were not there. I think the business environment is changing, and they want certainty in the application of the laws. We've opened up, and you'll find that even the licensing system has changed. I remember in Zambia, certain businesses were reserved only to Zambians, and in Malawi, certain businesses and areas were reserved only to Malawians. But now you can't go on with that type of business models. So it's different now. What are the challenges? Challenge number one is domestication. And this was brought to the attention of our ministers and to our presidents. This was 3 months ago in Kinshasa when at the summit as well as the Council of Ministers. It's a very important subject, and I think through tralac, they will pick it up. Because even the AU Charter, it is not only domesticated, but ratified. People just go there, heads of governments, they just go there. And they haven't even signed, because there is the signing, ratification, domestication. But all those things haven't been done. For COMESA Treaty, we found out when we were 3 months ago when we were in Kinshasa, We posed the question, how many countries they've ratified the COMESA Treaty? We said everybody. We said, yeah. But what does your constitution say? Most of the constitution, common law, they say after ratification, you go back to your country and domesticate the treaty, and none has domesticated. As Professor Rasmus was saying, for trade issues like customs, what they normally do is once they agree at COMESA level, they put in a statutory instrument. But that is not enough. You can't be every time. Yeah? There's one gentleman who talked about the England, the UK system, where we've got one incorporation act, that anything which comes from the EU, automatically it becomes law in England. So we've got to look at various methods for how to make the system workable and predictable and bringing in certainty and transparency. Unlike now, for a businessman, you have got to find this measure which was taken at regional level. Are they complying with it? If they are complying, where is the proof? And with so much turnover at ministries of trade, Ministry of Finance, sometimes I was asking each country, can I have proof that you have domesticated? Can you imagine the Attorney General saying, I don't know what you are talking about, I don't know. The Attorney General. Have you ratified the COMESA Treaty? Give me proof. We don't keep records. When was it done? No, it's true. Go back to your country and ask your counterparts at the Ministry of Justice. There are no records. Everything is in shambles. So that is problem number one. Now there has been a lapse of time, 2004 to now. You are implementing a document which was negotiated pre-2004. Because if you look at the document, it was looking at competition problems of that time. And at the time we were negotiating these regulations, the jurisprudence on competition, it was very minimum. The ICN, International Competition Network, it was not there. Nobody, very few people, even in Europe, very few people who knew competition. I recall when I was at Queen Mary studying competition, we were very few. The class were about less than 15. It was not known, even in Europe. So, 10 years down the line, we are supposed to implement that law. So there are a lot of gaps, and some of these gaps are very serious. There is need to undertake advocacy because of this lack of knowledge. And the advocates, it is easier to talk about advocates, but to put it into place, it requires money. The most dangerous thing is to get somebody who doesn't know the subject matter to talk about that subject. I think that is the eye Professor Mkandawule couldn't talk about. Ignorance in the region. So, for us to carry effective advocacy, we need first to train the people to conduct the advocacy activities. Capacity building. It's important that we go on and on, capacity building. We've tried, Trudy assisted in the 1997 up to 2002-3. Tralac got fed up. You don't do any advocacy in competition, do you? You have stopped, you're fed up. So we need that. We need to continue with that. So those are the major challenges we are facing. In conclusion, being a lawyer, an old lawyer, old-style lawyer, I'll go back to Roddy Denning, what he said about the community law. In 1974, in one of the first cases to come before the English courts, which questions of community law were raised, Lord Denning described the implications of community law for the English legal system as an incoming tide. It flows into the estuaries and up the rivers. It cannot be held back. So when we talk about integration, you can't hold it back. You can't. It's moving. We're not talking about tripartite. That's why it is important to gather amongst us and to talk about ways of monitoring in the integration process, how it should be done, and how we should drive the integration process. That was in 1974. In 1985, the Commission's white paper, writing on the same subject, said, completing the internal market suggests that even Lord Denning may not have foreseen the full force of the oncoming tide of community law. UK businesses that fail to take account of its implications as part of their business strategy to remain competitive in the single market do so at their own peril. This is true even for our business in Africa. The gentleman from the AU asked a very pertinent question he was asking Professor Mkandawire, that how do we bring the business on board on this integration process? Because we talk about trade, but we are not traders, are you? The person who's a trader here, when we are making laws for them, suggestions for them, talking about them, but we don't see we're talking about the trade, but we don't see the traders themselves with us. That's why the AU gentleman was saying that, you see, it's important that the business is also included into this discussion. I'm a Catholic, and I make sure that every law which comes from Rome, the Pope, although I stay at a very remote station in Malawi, we contribute, sir, Professor. I don't know why Malawi, they make fun of us. Zuma said the Lord in Malawi. And the professor said the remote station in Malawi. That's where we come from. So that's what I had to say about the competition process. It is there, and it is working. We've opened up. We've received so far over about 30 major acquisitions we've looked at. We are opening up now, coming up with a leniency program so that we see these cartels so that they don't manifest in the common market. Thank you very much, Chair.